Right now on the Daily Debrief.
I was eagerly just hoping and praying that I would be bitten by a snake.
Testimony about venomous reptiles from a father accused of playing a role in his daughter's death. Cross-examination was...
Yesterday was your third story, correct?
No, sir.
Okay, folks, welcome to the Debrief. We have a lot to talk about tonight. Linda Kenny-Bodden here in studio. Other guests joining us from across the country in just a moment. A jury delivered its verdict after, just moments ago, I should say, after you watched live testimony on the Debrief last night of a Texas defendant taking the stand and describing the death of his 3-year-old daughter. Wesley Matthews admitted to the lesser offense of injury to a child, and now a jury has decided that Matthews will spend life in prison. The victim was 3-year-old Sharon Matthews. The defendant said she disappeared in October 2017 after he left her outside to discipline her for not drinking her milk. He then changed his story and said she died while choking on her milk and that he hid her body in a culvert. On the stand, Matthews said his daughter was drinking special milk prescribed by a doctor and that she was ordered to drink it because she was underweight and had special needs. Here, the defendant describes his daughter's death over a failure to drink that milk.
I see Sharon standing with her bottle, holding like this with the straw going into her mouth. And I don't see any milk activity. Just I can see the milk staying in the straw, but I don't see her swallowing her milk. And I tell her, Sharon, hurry up and finish your milk. I say that to Sharon. It came out much louder than I expected, and it startled her. And immediately she tried to swallow what was in her mouth, and she tried to cry at the same time. She was startled, and so as a result, she started choking and coughing pretty soon because of that choke. And her coughing wouldn't subside. So I picked her up and I rubbed her back, I cupped her back so that her cough would be relieved. But it wasn't subsiding, and I saw that her coughing was getting worse. So I cried out to Mama, I cried out to Mama, and I kept saying, Sharon, come on, it's okay, baby, we can go back inside, but her coughing was getting worse, and at one point I felt that she was just falling backwards, and I had to support her with my right hand, and I felt that I could not control her, so I had to lay her on the floor. I was on my knees, I laid her on the floor just to make sure that she was okay, but her breathing had gotten much more heavier, and I tried to call Mama. I tried to gently shake Sharon so that she would be out of that spell, but nothing was working, and in a matter, I don't know, pretty soon, her head started going in either direction, and her head came to a still.
The defendant also described his bizarre thought process about hiding his daughter's body in a water-filled culvert.
I refuse to believe that my child had completely gone from this world. I believe that if I pray hard and strong enough, that God would bring my child back. I believe that the Lord God who brought Lazarus out of the tomb after 4 days can bring my Sharon back to me. And I was just being driven by fear of CPS and fear of how Cine is going to take this piece of news, and fear of losing my house and my family. I found these trees on the other side of Centennial, and I felt those trees were a good place for my child's body to be resting. But then I see this culvert, and immediately my heart is going, okay, so that culvert looks very dark. I cannot see anything at all. There is a very likely chance that I can crawl in the culvert with my Sharon, and there's going to be definitely a snake in there. And I was eagerly just hoping and praying that I would be bitten by a snake and I can be there in that culvert with my child. Together we can be in heaven with our Lord.
Prosecutors cross-examined the defendant by asking about his attitude toward his daughter and his attitude toward the truth.
You are never going to admit that you murdered Sharon, correct?
No, sir.
Yesterday was your third story, correct?
No, sir.
On your interview on October 7th, you constantly referred to Sharon as the girl, correct?
That interview is, I admitted that those were not truthful statements, and she was my little girl.
And then yesterday, you said Sharon's name in the first probably 8 minutes of your testimony more than you have in both interviews, the 8 hours combined. Would you agree with me?
I don't recall that, sir.
You don't recall that. On the October 7th interview, you told Detective Diaz essentially that you felt tricked by the Indian government about what kind of little girl you were getting, correct?
I did not use that exact same language.
All right, would you use the word that you got a defective girl instead?
That's not the language I used.
You don't use the word defects? You don't refer to Sharon as having defects?
Sir, English is not my primary language, so sometimes words may not exactly reflect what I am.
Let me ask you this. You saw the text I put up there yesterday, right?
Yes, sir.
When you said, I hope, or I wonder if she'll have any more defects, right?
Yes, sir.
Those are your words, right?
I don't recall that.
Usually the defendant and his wife shared cell phone location data. However, the defendant shut that feature off around the time his daughter would have gone missing.
You can turn location services on your iPhone. You can do it on a Samsung phone as well. You can do that with another person for a period of time, for an hour, for 1 minute, for one time.
We are right after
On this phone, it was done for a long period of time. It was turned off at 3:50 in the morning on 10/7.
You recognize that?
I do.
What is that?
This is a photograph that I created from Wesley's phone, showing that location services were stopped at 3:50 in the morning with Cindy Wife, and Cindy Wife stopped sharing location with you also at 3:50 in the morning.
Okay.
With us tonight to discuss this case are criminal defense attorneys Linda Kenny-Bodden in New York and David Schoen in Atlanta. So David, what do you make of this? We've got a life sentence now. Is that the appropriate sentence recommendation in a case like this?
Unfortunately, I think it probably is. It wasn't a capital case and shouldn't have been charged as a capital case. But this fellow undermined himself by lying at various stages. Remember, he held that police interview on October 7th, right after her death, and treated it as if it were a missing persons report or if there had been a kidnapping. He knew where he put the body at that time, and the jury learned that. When the body was discovered, October 22nd, it was where he had put that body. And now he has these stories that there were religious reasons and so on. He really undermined himself with all of those things. He gave himself a defense, by the way, in his story. Had his defense been he saw her choking and he shook her and maybe she died that way, he probably could have gotten forensics to back that up. But that's not at all what he did. He's a person killed
exactly.
his daughter.
You can't do that with a body that's degraded after being in a culvert for 3 days. Linda, snakes, hoping that snakes are going to show up and bite you and just make it all go away.
Oh, you know, I hate snakes more than anyone. My grandmother told me if snakes were good, the God wouldn't have made the devil a snake in the Bible. But let me just say this, Aaron. Remember in Scandarito, the judge in sentencing said it was a sophisticated plan? Once he turns off that sharing data at 3 in the morning, when you're not giving your kid milk at 3 in the morning, okay, that shows sophistication, and that is done him in.
And David, what's going on here with this language? A girl with defects, someone who's defective? He was on the stand saying, I felt like the moment that I saw her in an orphanage that she was my daughter and she was meant to be with me. That's what he said rather on the stand, and then apparently he's using this other verbiage. I mean, does the language issue make a good enough excuse for that, or is the language issue just a cover for something more sinister?
No, I think he came across poorly when he was fighting with the prosecutor about the words. The fact is, he apparently said in a text and otherwise that he felt he had been tricked by the Indian government because this little girl had defects or had genetic conditions they didn't know about. That gives a motive, unfortunately, to the jury. I don't know, the prosecutor, to me, went a little overboard with the words business, but he made the point in any event.
Exactly. David, appreciate your input tonight. Linda, I know you'll be here for the end of the broadcast. And day 3 of testimony now in the case of a Florida man accused of kidnapping and killing a woman and then dumping her body in a wooded area. Defendant Scott Nelson faces a possible death sentence if convicted in the killing of Jennifer Fulford. The victim was a personal assistant and nanny to a wealthy man, and the defendant is accused of taking her from the home where she worked, duct taping her face and ankles, tying her hands behind her back, and then stabbing her in the heart. A medical examiner testified that the victim died from asphyxiation and stab wounds.
Would the 2 stab wounds to Mrs. Fulford's back have been fatal to her?
In and of themselves, I don't believe so, no.
Would they have been painful to her?
I believe they would have.
Doctor, you also said that Mrs. Fulford had 4 stab wounds to her chest and 1 to her abdomen. I'm showing you what is in evidence that states Exhibit 55. What does that photograph show?
These are 5 stab wounds, 4 to the chest, 1 to the abdomen. Well, the stab wound to the pulmonary artery, again, which is a major artery going to the lungs. If you're stabbed in that, you can bleed out. The stab wound going to the heart, again, you will bleed out. The stab wound going to the left upper lung lobe, you will bleed from that as left upper lung lobe. You will bleed out as well as causing a pneumothorax, meaning your lung may collapse. The stab wound going to the liver, again, you will bleed from.
Now to the trial of a different Florida man. It resumed today after a conviction on 3 murder charges. A jury must now decide whether it's life in prison or the death penalty for the man they found guilty of murdering 3 people at a party, Christopher Vasada. Testimony revealed that the party involved drugs and possibly drug dealing. While many made statements to remember the victims, the defense claimed few people would testify on behalf of the defendant, Vasada, because of the presence of cameras in the case. The best female hip-hop artist of the year has faced a judge in New York City. Cardi B pleaded not guilty to upgraded charges after a fight in a strip club. She faces 11 counts, including 2 charges of felony attempted assault. Cardi B is accused of ordering 8 people to assault 2 women she suspected of having an affair with her husband. Still ahead tonight here on The Debrief, a breakdown of new body camera footage showing interactions between Chicago police and actor Jussie Smollett. And then a verdict in the penalty phase of the McStay family murders is in the books. The Debrief, however, has final thoughts on the behavior of the prosecution when we return. Chicago police have released body camera footage of their interactions with actor Jussie Smollett. Chicago prosecutor Kim Fox dropped charges against Smollett, a move which is currently under investigation by a newly appointed special prosecutor. The police say Smollett made up a so-called racist and homophobic attack. In releasing the recording of the first interaction with Smollett, police blurred out Smollett's face and that of his manager. Here is that new recording.
And the reason I'm calling because of this.
You want to take it off or anything?
Yeah, I do. I just want to see. There's a bleach on me. Bleach on me.
Okay.
You're filming us, right?
Yeah, this is all being. If you want, if it's in his house.
They're filming you.
You're being audio and
Like audio. I guess when I mean, they didn't know when they were walking. I don't want to be filmed. Okay, so can we turn it off?
Yeah, you're giving us permission to shut it off.
Okay, and there you saw the noose that he said was tied around his neck. In another series of videos, Chicago police showed how the 2 brothers from Nigeria, who are said to have been in on the attack, were riding in a cab wearing all white, and then right there were seen running past a hotel lobby in the moments before and after the police say those brothers were paid to perpetrate the supposed fake attack on Smollett. In yet another series of clips, police showed how they moved in and arrested those 2 brothers on a return flight from Nigeria. Both eventually cooperated with police and explained how Smollett paid them $3,500 to attack him, with another $500 promised when they returned to the United States. A sentencing recommendation from the jury in the case of Chase Merritt. He's the California man convicted of killing all 4 members of the McStay family, starting with business associate Joseph McStay and then dumping the family in 2 shallow graves in the desert. The recommended punishment was a mix of life and death.
penalty verdict, we, the jury, in the above entitled action find that the appropriate penalty as to count 1 for the defendant, Charles Ray Merritt, to be life in prison without the possibility of parole, dated June 24, 19, signed by the foreperson. Title of court and cause. We, the jury, in the above entitled action find that the appropriate penalty as to count 2 for the defendant, Charles Ray Merritt, to be death, dated June 24, 19, signed by the foreperson. Title of court and cause. We, the jury, in the above entitled action find that the appropriate penalty as to count 3 for the defendant, Charles Ray Merritt, to be death, dated June 24, 19, signed by the foreperson. Title of court and cause. We, the jury, in the above entitled action find that the appropriate penalty as to count 4 for the defendant, Charles Ray Merritt, to be death, dated June 24, 19, signed by the foreperson.
Now, there is something else I feel compelled to address in this case, and that is the behavior of the prosecution, which, in my personal opinion, has been juvenile and unbecoming of professionals who are paid public money to serve as ministers of justice, not just as advocates in a public court of law. Let's look at what our cameras caught in court.
One might think the gravity of the deaths of 4 people or the gravity of seeking to put a man to death warranted the prosecution's full attention. Apparently, it did not. During defense closing arguments, prosecutor Sean Doherty felt the need to text someone as the defense presented the most critical argument which can ever be delivered in an American courtroom, an argument to spare a man's life.
This decision is not based on revenge.
With buzzwords like decorum and professionalism in the legal community, ask yourself, does this conduct by the prosecutor stand up to those expectations? The texting went on for approximately 10 minutes in full view of the jury. At one point, prosecutor Doherty appeared to share a laugh with Detective Ryan Smith as the defense tried to focus the jury on whether defendant Merritt should live or die. I personally don't think it's a laughing matter.
This is the case of the people versus Charles Merritt. This is not a case against Sean Doherty, Britt Imes, Melissa Rodriguez, despite the fact that we've been attacked constantly throughout it.
During closing arguments in the first phase of this case, prosecutor Melissa Rodriguez slammed the defense, but she never apologized at any point for the time she turned her back to the bench and crossed her arms in apparent disgust during a judge's ruling. The jury was not present for this, but still, what message does this body language communicate to the community? Does it send the message that the prosecutor thinks she's smarter than the judge, or maybe that she thinks she's above the law? Even in the heat of argument, should this behavior be acceptable in any court proceeding? Ask yourself that. Though Chase Merritt was the man on trial, the prosecution carries the burden, remember that as well. And at several points during this trial, the jury was present for head shaking by the state during critical moments of the defense argument. Ask yourself, is this a distraction for the jury? Does it unfairly take away from what the defense is arguing? Does it take away from the defendant's right to a fair trial? Does it deflect the burden away from the state? Does it turn accusation into fact? Does it create a due process issue under the Fifth Amendment? The Founding Fathers refused to give the government the power to take a man's liberty or his life easily, because a system which allows swift, easy punishment can easily be abused. Despite unknown DNA in the victims' graves found by the defense and which the prosecution refuses to test, prosecutors successfully convinced the jury that Chase Merritt was guilty beyond a reasonable doubt.
We, the jury, in the above entitled action, find the defendant guilty of the offense of murder.
Maybe the jury doubted the defense case because the prosecution's behavior distracted the jury away from following the defense witnesses or the defense arguments, just maybe. And if this jury was lulled into a sense of disbelief toward the defense by a prosecution whose job it is to shoulder the burden in a criminal case, then the ramifications for justice are disturbing. Now, in the name of fairness, I have asked the prosecutor's office for comment on these matters. None thus far has been forthcoming. That is my opinion. Let's see what the panel thinks. Judge Ashley Wilcott joining us from Georgia. Judge Wilcott, would this happen in your courtroom? Why or why not?
Well, here's the thing, Aaron. Could it happen once? Absolutely. We're all human. Trial attorneys are human. The problem I have is that it's happened more than once. If I were to observe as the judge on a case that this type of behavior was occurring more than once by a prosecution or a defense, I would be very even-handed. I would tend to call them up outside of the presence of the jury to explain courtroom decorum, to let them know if there's an emergency they need to text about, they need to let me know that. Otherwise, I would not expect nor accept continued behavior like this in my courtroom.
Former federal prosecutor Gene Rossi, your opinions on this. Did you text in court, Gene, when the defense was giving an argument to try to save a defendant from some punishment when you were a prosecutor?
The courthouse where I rolled, they didn't allow your texts in the courthouse. But when I did go to courthouses with my phone, I never text. And there's a judge named T.S. Ellis III. He did the Paul Manafort case. And if you made any faces, if you grimaced or used any body language that was disrespectful, he would admonish you in front of the jury the first time. He wouldn't give you one bite at the apple.
Okay, Linda Kenny Bodden, you defend accused criminals in court. If you're the defense attorney up there and that behavior is going on, how big of a distraction is it? Is this as serious as I take it?
Yes, you call it out. And remember, I know you don't like Casey Anthony, and some of our viewers don't like my co-counsel then, Jose Baez. But remember, he called one of the prosecutors out. When I was a prosecutor, we were taught you don't want to show very much interest, okay, in the other side, but you never show disrespect. So you can kind of sit there and you kind of look down. Maybe you can write a few notes, but you don't laugh unless there's something that everybody is laughing about.
You don't roll your eyes. You don't distract. You don't try to give some sense that whoever's on the stand might be lying by shaking your head in the middle of it. So ultimately, how does this thing land? Ashley Wilcott, we've got about a minute left here. Do you think it's possible this could have affected the outcome?
Well, I do, because to me, if you're watching that as a juror, you may think either A, oh, we shouldn't even take the defense seriously, or B, that it's a laughing matter, that the seriousness of what the jury has to do doesn't exist. So I do think it's an issue that could affect the outcome of this case.
In just a few seconds, Gene Rossi, your thoughts.
I blame the judge too, because a good judge, not the 8-ball judge that I call him, would have admonished those attorneys to stop what they were doing.
Okay, those are our opinions, the three of us. I hope that we're well informed enough to be able to speak on this matters. We've got a judge here. We've got a criminal defense attorney here. We've got a former federal prosecutor here. Appreciate the insights in the panel, and thank those of you for watching us here on The Debrief tonight. Our live trial coverage will pick up at 9 o'clock in the morning Eastern Time here on the Law and Crime Network. The Debrief will be back live tomorrow at 5 p.m. Good night.